Hello, my name is Simon Appleyard, Regional Manager for Wesleyan Financial Services.
Hello, I'm Leyfield, Account Manager, also for Wesleyan Financial Services.
Welcome to today's discussion on the key aspects of GP partnership agreements and how they impact on personal and business financial planning.
We're in a world in general practice, certainly with GPs, where we're constantly hearing about the numbers of GPs looking to retire early or take phased retirement or retire from the profession. And obviously the majority of GPs, up to 2/3, are partners in practice, so partnership agreements forms a key part of their retirement planning. What are your experiences around that?
I think it's a very important part of the partnership agreement to be very clear about what it says and the implications for a number of reasons. And that goes from simple things like how much notice do you have to give? It's all well and good saying you're going to fill out your AW8 with 6 months and off you go, and I'm expecting to be able to retire when I want. But if your partnership agreement has restrictive covenants there about how many can retire at the same time, you might find yourself hanging on because other people have beaten you to it. So I think that's a starting point, is can you retire when you want to retire, or is that crossing over with other people's retirement? Because your partnership agreement needs to make sure there's continuity in the business. So you should have covenants in there. Another aspect I think that isn't immediately thought of is on retiring from the practice, if there has been a share, an equitable share in there, be it with obviously the capital account or more importantly with a building, what are the terms and conditions of there? What does the partnership agreement say about what happens to your share in terms of how quickly is that going to be paid to you if you're relinquishing it? Can you keep hold of a share of a building if you don't want to let go of it, and what your responsibilities are in that, and how that share might be valued? Because again, from the business's point of view, there's two ways of looking at this. From the remaining partners, they want to be able to protect the financial integrity of the building by, putting limits on who can take what out at what stage. But as the person going, you want to know that you're going to get your share in a timely fashion and it's going to be valued fairly. So that's quite important. The other key thing when it's about restrictions, and there's two things here. One is around the roles that you might have outside of clinical sessions. So quite commonly, as you know, there are other roles that could be that you do pathology work. It could be that you do educational work or research, and set up in such a way that income actually comes in via the business, via the practice. And you might have the nice idea that, well, I'm going to stop doing clinical, I'm going to retire, but you know what, I love going and doing that bit of lecturing, I'm going to carry on doing that. And you find that actually the partnership agreement says, that's a role that comes with the practice, and someone else is going to take that on. Or even there's a restricted covenant that says you cannot work within a X amount of miles of the practice in any kind of role related to those which you've been party to so far. Well, that could change your plans significantly if that's in place. The other one is around retire and return, and I know you've seen plenty of examples of this.
24-hour retirement. Yes, it's one of those things that has been a really common tool for GPs and GP partners specifically, as we're talking about, to almost take a phased retirement, start drawing their NHS pension income, continuing work and so on. And for so many doctors, that's been a brilliant way of both continuing in the profession, which is great for the practice individually, for the profession generally, and for the individual doctor to start moving towards retirement. It's a brilliant tool. But again, your partnership agreement is a key part of that. we've talked about some of the areas where the agreement is the specialist need for advice specific to a GP practice. 24-hour retirement is a great example of that. Because whilst the NHS pension scheme may allow you to do that, and you're thinking, well, I can apply for that, I'm going to kickstart I know the rules for the pension scheme. Have you looked at what the rules for your practice are? And typically you will see covenants in a partnership agreement that say to effect that with the consent of the remaining partners, you're entitled to take 24-hour retirement. Great. Make sure you've raised that. You've got that documented. The partners have agreed it. Good luck to you. Enjoy receiving your income from the pension scheme. But if it's not mentioned, do not underestimate the fact that 24-hour retirement is still retirement. It is a tool and mechanism to start drawing your pension, but it is still a retirement. The extreme examples, and I know of this happening at least twice in my time, is of a partner applying for and getting NHS 24-hour retirement, and then being told by their practice, "Oh, sorry, that's the end of our relationship. You've retired," because they've not agreed the return part of the agreement. I suspect there might have been other issues and other challenges there, but whilst that's an extreme, it's still part of your retirement planning to make sure that you are working you understand the rules set out within your partnership agreement, and that you've discussed and communicated with your practice, your partners, your intentions, and they, if you're in the position of being the one still there, that you would expect that of those of your colleagues who are approaching retirement to be talking to you about their plans, so that actually that protects the person retiring and allows the practice the chance to plan and contingency plan and continuity planning probably years ahead of the event, 3, 4, 5 years out. Somebody knows that I'm planning to retire at 60. At 55, when those conversations are not inappropriate to begin at that stage.
Absolutely, absolutely. I mean, one of the key things that we do for our clients is proper planning of the pathway to retirement. So a long way out, we will sit down with people. We will look at all these areas. We'll look at partnership agreements. What's the mechanism there? We'll actually start with, well, what do you want to happen in retirement? You know, is it a cliff edge straight in? Is it a soft landing? What are you going to do in retirement? We'll establish that and then model it. Cash flow modelling to actually look at what income you're going to need, what capital you're going to need, to make sure that's all in place so that it's a smooth journey. And making sure it fits with the partnership agreement is a crucial part of that. And in terms of getting your share out, if you're an equity partner, or, as you say, just being able to retire, it's fundamental.
You mentioned premises there, and premises is really interesting when we're around retirement, because we've spoken about it in terms of getting your share of any ownership out. It's not uncommon that actually retaining an ownership and an interest in the ownership of the premises is part of the individual doctor's retirement plans. And in many cases, the ownership of premises is very different from the current list of partners in a practice, to the extremes where actually the premises is owned entirely by retired former GP partners. And again, we talk about the importance of business protection and how a partnership agreement, although it's likely to be a second document, the ownership and the mechanics and the rules of how the responsibilities for the premises are outlined are hugely important. So if you are a partner in a practice where the premises is owned, you may not be an equity share owner in that. It might be a small number of the existing partners, or some of the existing partners and some retired partners, or even entirely retired partners. But make sure that you've got something which outlines who's responsible for what. I'll give you an example. working in partnership with a national firm of GP specialist solicitors a few years ago. They highlighted a case where CQC had visited practice and required a whole host of changes to be made in order for the practice to continue operating as a GP surgery. The partners in the practice didn't own the premises. It was owned by one or two retired doctors. They turned to their effective landlords and said, well, we need to make these changes. The landlords went, well, no, you're the ones who want to run it as a GP business. You need to pay for them. We have a dispute because nobody was clear on who was responsible for it.
Right.
And that's where we end up in litigation, potentially the huge cost of that, and the likely outcome of it'll be a compromise that nobody's happy with.
Oh, absolutely.
So, yeah.
Absolutely. And I think that sort of highlights something else which we haven't touched on so far, and perhaps we'll talk more about another time, which is in a situation like that, what happens if that retired partner dies? Where does the share of the premises, who does that then sit with? And that's true within a partnership itself,
Absolutely.
and that's another fundamental death of a partner in harness. Who then owns that share of the building, and what does that mean from a business protection point of view? But perhaps we'll save that for another day.
Absolutely. Thank you for watching our video today. Hope you found it interesting. At Wesleyan Financial Services, we're specialist financial advisors to GPs and GP practices. So if you have any questions and would like to find out more about how some of the topics we've talked about might affect you, please visit us at wesleyan.co.uk.